Yeah,
and financing. There's so many housing issues to talk about.
right.
How are you? Are you excited for this weekend?
Yes, I am. I think we're live now. So welcome
Fabulous.
everybody to Win Without Law School, our special Thursday live. I'm Julie LeBenz and my
I'm Billy
amazing colleague,
Tarasio.
Billy Tarasio. So welcome everybody. We're going to talk about divorce and housing rights today. Oh, you know what? I need to move my microphone over.
Yeah, no problem.
This better?
Yeah, it's great. It is better.
So today we're going to talk about divorce and housing rights, and there's been some new developments in the law. Housing is a really major issue right now with just all the housing crunch going on. So I'm sure a lot of people have questions about how all of this works. And we're really going to talk about in the divorce context. And man, everything is changing in your life when you're going through a divorce, and housing is a big issue. And that can be really tough too, because maybe you've lived in this house for the last 20 years and now you need to find a new place. And that can be really sad and difficult.
Yeah, I think the housing issue in divorce is just a huge one. You know, there's the issue of like, what's the valuation date? There's the issue of who pays the expenses. There's what happens to all the stuff. There's just so many issues surrounding housing. There's the loans and whether or not you're required to refinance if you want to buy your spouse out. So it's hard to even know where to begin, Julie. And then there's also separate property, community property, disclaimer deeds. We have to talk about that.
Yeah, I think a good place to start is this concept of exclusive use of the house. And there's a couple of different ways that one spouse can get exclusive use. And this can be really dramatic. I mean, under some of these options, you could go in, get an ex parte court order that gives you exclusive use of the house. And then a police officer can come and serve your spouse, and they have like 15 minutes to get some property out of the house and then find somewhere to stay. So this can go down in a very dramatic way, which of course gets your divorce off to a very rocky start.
Yes.
Or there can be a greater discussion about what happens, but often you just can't live together anymore, right?
Yeah, so some people do. They live together throughout their entire divorce.
I'd say that's rare though, don't you think?
Oh, good question. Is it rare? I've certainly seen it more than a handful of times. But I think it is the minority of the time. Most of the time when you're going through a divorce, you can't live together or you've separated first or whatever. Yeah, it just depends. Oh, we have not done a proper disclaimer.
Oh, that's right.
Right. So I'm Billy Tarasio, Julie LeBenz. Hello on TikTok. Hello on Facebook. We do about a half an hour of informational programming for you. And then we take your Q&A. So go ahead and send us any of your questions, either on the Facebook group, Decode Your Divorce, or on TikTok, and we will get to as many as we can. We always run out of time, but the faster you ask your questions, the more likely we are to get to those questions. We are Arizona lawyers. We're not your lawyers. What we are providing is legal information, not legal advice. If you want legal advice and you're in Arizona, you can contact Julie, whose firm is in Sedona, or me at Modern Law in the Phoenix area. I think that covers it.
Yeah, awesome. So, with this exclusive possession, there's a couple of ways to get it. You could potentially get an order of protection if you qualify, or you can seek a temporary order, which in Win Without Law School this week, we did a ton of trainings on temporary orders. And in a divorce, you can file a temporary order and ask the court to award one party exclusive use of the house, and the court can order that. And interestingly, it can even be if it's not a marital home. You could ask the court to award you exclusive use of a separate house that's owned only by one spouse.
What? Wait a minute. Can I ask for exclusive use of a house that's owned completely by my spouse or partner?
You can.
Do you need an order of protection?
Yes. In fact, I had a case recently where that happened, and the wife was the owner and she got kicked out by order, and she was literally like living in her car for a few months until it all got straightened out. It was really sad.
When you talk about this dramatic order that comes out of nowhere that's ex parte, the only way that I've seen that happen is when someone goes to get an order of protection. Have you seen that in the family court or only through orders of protection?
So through the ex parte, yeah, I've generally seen that through the order of protection. But technically, you can seek an ex parte temporary order if you had cause and could seek that as one of your remedies. However, most likely you're going to go through the with notice procedure for the temporary order and give your spouse notice that that's what you're requesting and work through that issue. But there's going to be a lot of details to work out. You know, who's going to pay for what? Is there going to be some sort of reimbursement claim down the road? What does the spouse that can't live there, you know, is there some money going to them, additional money to help them with housing? How's this affecting the children involved? You know, there's all sorts of things that can arise, but the bottom line is the more dramatic and the more conflict involved, the more your attorney's fees are going to be if you're working with a lawyer, and probably, you know, the longer your overall case is going to take because you're on this really litigious footing if you go that way. Now, it is possible you rock the boat and there's this big dramatic thing and then you end up reaching an agreement because of it. So sometimes the big dramatic stuff can work in your favor, but oftentimes it's just very expensive.
Right. Yeah, I agree.
So that's exclusive use, and that can also apply to pets too. So it's not just the house, you can also get exclusive use and possession of animals either through a temporary order or through an order of protection. There's new case law, and there's actually been a lot of cases coming out of the Court of Appeals on this issue in the last year or two, which is this concept of contribution. So if one spouse is possessing certain community property while the divorce is pending, are they responsible for all the payments, or does the other spouse still need to contribute to those obligations? And this is really interesting with housing, because I had always looked at this like, okay, whoever's in the house, they need to pay for the expenses because they are also getting the use and enjoyment of the property. But the recent case law coming out is saying not so fast.
Right.
The other spouse who is not living there may have a duty to contribute to those expenses unless they were ousted, which is really interesting. So ouster is a legal term. It's not the most clearly defined legal term. I've had it come up in a couple of cases lately, and there's not a very clear-cut definition. But essentially, if you want to continue cohabitating through your divorce, but the other side kicks you out, that would qualify as an ouster.
Right. Or if they create a hostile work environment or a hostile environment in the home. So it doesn't have to be as dramatic as you can't live here. You're able to make a claim that whatever was going on made it impossible. So it was like a constructive, to add a legal term.
Maybe you were getting threatened, you know, with violence or something like that, and you needed to leave to protect yourself.
Yeah.
So yeah, that could be a constructive ouster.
And so it's really interesting because let's say somebody is keeping the house and somebody moved out. You have a few issues. The person who's staying in the house, who's making the payments, they're making those payments with separate property, because once you file for divorce, your income is now separate property. So they're paying down the mortgage with money that is not community money. This is important because when we figure out what's the valuation date of the property will also incorporate how long the mortgage was paid down and at what dollar amount. So there's so many issues with housing.
Yeah, there are. And that, you know, this is very complicated. And in the past, it seemed like it was a very straightforward issue. Like, okay, you guys aren't going to live together anymore. One spouse is going to get new housing, and now you each just pay for your own housing and we're good. But now it's not so clear cut. And you could be paying for your own separate apartment, but still be needing to contribute to the other side. Now, hopefully the numbers all work out and there is no contribution. But if the housing expenses aren't, you know, similar or of equivalent value, there could be some contribution claims. And then you're paying even more money at a time when your money is likely pretty tight because of the divorce. So that could be a really tough pill to swallow. And I've been a bit surprised at the court's take on these issues, even though I understand it, but I've kind of been a bit surprised by it.
Yes. So this came up in one of my recent cases, and I just want to lay out the example because it might make more sense if I explain an example. So dad lives in the house. The house mortgage is about $2,000. Mom doesn't live in the house. She lives elsewhere and pays for her own housing. We needed to determine, and we represent mom, we needed to determine if mom was going to have an obligation. So we needed to get an appraisal of the property. In addition to getting an appraisal of the property, we asked the appraiser to also do a fair market value assessment of the rent, because part of this Bo Brow case that you're talking about sets the contribution amount depending on this rental value. So it was determined that the rental value of the property was about $4,000. So husband could have rented out the house for $4,000. That means wife could only be on the hook for $2,000. And since husband's mortgage was $2,000, she was good to go. So even without proving ouster, she would have been defended or, safe under Bo Brow under that analysis. The other option, let's say it had come in at $3,000. Let's say the market value, rental value was $3,000. Husband's paying the $2,000. Now she could be on the hook to contribute for that other $500, let's say, unless she can prove ouster, that he made it, that he told her to leave or made it a hostile environment. So this has now increased legal fees because we got to do all this analysis.
And let's make a distinction between the mortgage and the utilities, because it's my understanding that those would be treated differently. What are your thoughts on that?
You said that. Now I think the Bo Brow case was specific to the mortgage, right?
Because that's a community debt.
Yes, it's a community debt. It didn't touch the utilities. I think the utilities are on the person who lives there, I think.
That's my understanding too, because they're actually using the water and the heat. And so because they're using it, they need to pay for it. I had one client be like, yeah, but even if they weren't living there, there would be some sort of utility expense. Well, okay, you could factor that in, but it's going to be minimal. Right. So really, I think the utilities are a non-issue, but what about upkeep? What about landscaping? What about, I don't know, just various upkeep issues with the house? Those could bring on a contribution claim depending on what they are.
Absolutely. The house needs a new roof in order to sell. I've seen this happen many, many times where the spouse who's in the house, who's now responsible for getting it ready to sell, had to put on a new roof in order for it to be listable. And then they're asking for contribution, or they're asking that a dollar amount be taken out of the equity of the spouse that they were going to be paying out because they had to deal with putting on a new roof. Makes perfect sense, but it's pretty complicated.
Yeah, and you definitely don't want to just move forward with improvements during a divorce without notifying the other side, having some really clear communication. Because if you just move forward with improvements without an agreement, you may not get credit for them, depending on what the improvements are.
Yeah, absolutely.
So now
let's talk about valuation date. When I first got licensed in Arizona, we were in foreclosure mode. It was about 2010 when my office opened in Arizona, and everyone was upside down and we were fighting over negative equity. And now, or in the past few years, we've been in this huge housing boom. And the question is, like, if somebody, let's take my example where wife moved out, if the house appreciates during the divorce, but while she doesn't live there, does she get part of the appreciation? What's the valuation date of the house?
So according to the law, the valuation date is whatever is equitable in the circumstances. So it's going to be a case-by-case analysis. And generally what I find is that courts are very practical with this. So if the house is going to be sold, then the valuation is whatever it sells for. If you've got like a stock account, then it'll be the value at the time of division. If you're going to try to say, oh, I want to use the date the other side was served with the divorce as the date of valuation, you have some complicated issues that are just going to arise just in all practicality. Because if the value of that account has decreased, then where do you come up with the additional money? So really the courts are looking at this on a really straightforward way. How can we do this very fair and also not necessarily put somebody in a place where they need to pay more? Now, interestingly, the case on this, I think it's called the sample case. And in that case, while the divorce was pending, there was a particular stock account, and there was some stock split, and it ended up being worth like $1 million during the divorce. And the husband was like, no, this is mine. You don't get the increased value. This is going to me, da, da, da. And the wife's like, no, just because this happened during the divorce, like I should still get an interest in this. And the court ultimately ruled, yeah, she should, that's fair. And so really the court is not going to take some hard and fast date and apply that in every case. They're going to look at what's fair in the circumstances. But if you have an account, like a bank account or a stock account, determining the value can be easy. You just see what the statement says. But a house, a car, other things where determining the value, you may need to hire somebody to do a valuation. Those things can be much more difficult and cause a lot more issues in the case. And then you have changing values too. Like right now, the housing market's changing. You could get a valuation done 4 months ago that's no longer good.
Right. And so one of the ways that you can kind of influence the value that the judge decides to use is by the date of your appraisal. Because if that's the only value they have, that's probably, practically speaking, what the judge is going to use. So if you think the housing market is going up or down, you need to make a decision about what you want your appraisal date to be, depending on what it is you're looking for.
Yeah, and then there's a real nuance I'll share here, which is there's a difference between a refi appraisal and a market appraisal. So if your spouse is like, well, I want to keep the house, so I'm going to refinance, and we'll just use the refinance appraisal, keep in mind that is likely going to come in lower than the market value. So I had a case a few years ago where husband wanted to do that. I represent a wife, and we went and got a separate appraisal done, a market value appraisal. And then the judge ended up splitting the difference. But still, it did result in my client getting additional equity in the home, which was helpful. But there can be a substantial difference between those two types of appraisals.
Absolutely. Totally. Absolutely. I'm surprised they split it, because the value should be market value and not what the bank is willing to finance. But because the judges have discretion, it really is up to them. Let's talk for a bit about disclaimer deeds.
Yeah, definitely. So what is a disclaimer deed?
So a disclaimer deed is a document that you sign, or that someone signs, that disclaims their interest. It gives away their interest in property. And these are signed many, 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 many times as part of a closing on a house. Many times somebody's asked to sign a disclaimer deed. It might be because their credit's bad. It might be because they don't want ownership of the house. It might be because usually it's related to your separate property, and you're intentionally, if my husband, let's say I was married, got a huge settlement or an inheritance and bought a house that I knew I didn't have a legal right to, and I signed a disclaimer deed, that would be just and proper, and I would be disclaiming my interest. The other time that it happens, many, many, many times, is when you're going to refi or you're going to buy a house and somebody has better credit than somebody else, and you're going to get a better rate if the person with bad credit disclaims their interest. And when that happens, it's a real conundrum, because you've disclaimed your interest, but it's technically community property.
So this was a source of huge case law over the last few years, went all the way to the Arizona Supreme Court. And the court took a very practical approach, basically saying the disclaimer deed stands no matter what. And I mean, I shouldn't say no matter what. There are a few exceptions for fraud. There was a case years ago where it was like a mail order bride, and she didn't understand what she was signing. She didn't speak English. Her husband was like, just sign here, and she signed. And that was undone because she didn't have any understanding of what she was signing. But for the most part, these disclaimer deeds are going to stand but for fraud. And it's sad, because usually what happens is the husband and wife make a mutual agreement. They say, oh, wife, you have better credit. And if we refi, we can get this really low interest rate if we do it just in your name. And in order to do that, the bank is going to require that I sign a disclaimer deed. So let's agree to do that in the interest of our marital community so that we have this lower rate. So I feel like it's not fair under the law because really it is a mutual agreement by the parties to do this in the benefit of the community.
Right.
But what turns out is it ends up creating a separate property interest in
Right.
just one spouse that upon divorce, they get all of that interest. There can be some deductions for community claims and stuff, but for the most part, they get the ownership interest. And that can be a really tough pill to swallow.
Right. Right. So, then these community lien claims come up, and there's also a ton of case law on community liens. You're not exactly SOL, but you are fighting an uphill battle, and you now have an obligation to prove that the community has an interest in this house that you've signed away your rights to. And there's absolutely ways that you can do that. If you can show that the community has contributed either through wages or paying down the mortgage or doing improvements, you're going to be able to make a community lien claim. But once again, this makes things more complicated. It makes the cost of litigation go up, and now we're doing math, and it's just harder.
It is a lot harder. And I'm curious, I haven't seen this yet and I haven't done it, but I'm curious if spouses reach this agreement, did the refi, did the disclaimer deed, but what if they entered a separate contractual agreement saying, despite all of that, this is what we're agreeing and this is still community property? Do you think that would hold up in court?
I absolutely do. I absolutely do, because it's a question of intent. If you're giving away a community property right, there was argument for a while that the disclaimer deed should be analyzed as a postnuptial agreement. Postnuptial agreements require actual information and consideration before you give away your property rights. I think that's fair, but the court has said that they're not going to analyze disclaimer deeds the same way. If you add in another document explaining the intent, I think it would stand, but that's just my opinion.
I think so too. Most people don't think to do that because, you know, they don't understand all of this, or you're not like divorce planning, you know, while you're getting along and everything's going well. But I think that is what we should be advising our clients if that comes up. And I think it should be more of a standard part of the procedure, because it does make sense to take advantage of a good interest rate.
It does.
But you shouldn't have to give up your marital interest to do so.
Right. Right. I completely agree. This is one of the problems with real estate agents and title companies practicing law. And they really are. They really are practicing law by putting a legal document in front of someone and saying, signing it. Most people do not understand what they are signing away and what they are agreeing to when they sign that disclaimer.
Oh, no, they have no idea. They don't get it at all. So it's really important, anything with real estate, to understand what you're doing before you sign a document or record a document with the county recorder. Mm-hmm. And one additional part, we'll get to Q&A shortly, is that when you are handling a divorce, and let's say you're representing yourself, and one side is getting the real estate, please get legal advice on this. Because if you have a mortgage in both of your names and you just transfer ownership of the property to the other side, then you're still jointly obligated on the mortgage and it's a total mess.
Right. It'll eat up your available credit. It'll make it harder for you to get your own house. Like, don't sign over your property right, or the rights to the property, the quitclaim deed, without getting off the mortgage. Require a refi or an assumption of that mortgage.
Yeah, that can be a major problem. And then also, if you start trying to do your own real estate deeds, you know, a lot of people don't understand what a legal description is, and they'll put something that doesn't apply, or they'll just write the property physical address, and then they don't put the proper legal. There's just a lot of detail that goes into a deed, and it really should be done correctly when you're dealing with real estate worth thousands of dollars, or hundreds of thousands of dollars, because you're looking at potentially putting a cloud on the title, which then could create more litigation and expenses and just problems for you. So I would not jump into any sort of real estate, documents related to my divorce without getting legal advice, because there's just too much on the line. And with divorce, you cannot modify a property division agreement. So you could put everything into your decree, do it, and then realize a year later that this is a total mess. And you go back to the court and they're like, sorry, we can't help you. We can't modify this. So It's really important to do it right the first time.
It is. People don't understand. We had pro bono day yesterday. I talked to somebody yesterday who entered into an agreement in 2020. Wasn't a good agreement, and there's nothing we can do. We are bound by the terms of the agreement. Even if you were devastated, even if you were trying to save the marriage, even if you were doing everything you could to just keep things amicable, just so that you would get back together, and you didn't really mean it, there's nothing that we lawyers can do to get you out of it once you sign these legal documents. It's not really fair, but it is the way it is.
And Billy, as a side note, this thought of I did it to save the marriage, I never see that thought process working out.
Never.
Never. It's always something that ends up being a decision that's regretted. It's a bad decision. Please, people, stop doing stupid things to save your marriage.
Right. Stop thinking you can save your marriage by giving up your rights. It's not going to work.
Giving up your rights or buying something that the two of you can't afford. Or, there's usually something that you give in to the other person that really you shouldn't be giving in on. And then you end up getting divorced anyways. And now you've got, this land in the middle of nowhere that you bought together thinking you were going to build a house on it. And now you've just got this land that's a total waste of money. There's just, I hear it all the time. Oh, well, I did that because I want to save the marriage. And I'm just like, don't.
It's not going to work.
Stop.
It's not going to be effective.
You shouldn't have to bend over backwards to save your marriage. If it's that hard, then there's a reason why it's that hard. And listen to why it's so hard. And don't try to bend yourself into every sort of contortion you can to make something work that is just not working anymore.
Right. I mean, and it's so easy for us to say because we understand divorce. We understand, because we look at divorce, we understand relationship dynamics. We understand like that when marriage is going to end, it's going to end. But for somebody who got married, intended to stay married, and has heard their whole life, you need to fight for your marriage. It can be so hard to know when you're just, kind of screwing yourself versus fighting for your marriage, which you've been told to do your whole life. It's just challenging. I feel for you.
It is challenging. And I really encourage people to break free of what I believe is a total false notion that you need to stay together till death do you part. I really think that should be taken out of the vows. I think it's completely toxic and antiquated and no longer applies. You should stay together as long as your souls are growing together and you're happy and it's working, but this isn't slavery and you're not bound to each other just because you took, some sort of marital vows.
Right. You're not each other's property. You're not, but that is not what historically has been true for property. It's not what religiously is true for marriage, not property, but, and so you're right. The toxic kind of dangerous messaging around marriage and very controversial, even for us to call the marriage pressure toxic or antiquated is controversial because most people, when they take these vows, they mean them fully.
And they do. And I honor that. But because you had a certain point of view and took a vow in your 20s doesn't mean that's going to resonate with you 20 years later in your 40s.
Right. Or your 50s or your 60s. Absolutely. All right. We have lots of questions. I have a divorce settlement in Arizona from 2020, but he has not paid. What do I do?
So this could be a good grounds for an enforcement action. So we do cover that in Win Without Law School. We've done videos on how to initiate an enforcement action and pursue it. But essentially you need to point out all the details of the underlying order. What are the parts that you're saying have been violated? What's your proof of violation? And then one of the most important parts is what are you asking the court to do about it?
What do you want? What is your proposed remedy? Yes, you absolutely have an enforcement action. All right. I just had a EDCM review this morning. There was no resolution. I received an email from my ex's attorney saying he was no longer obligated to pay the utilities. I'm not working at the moment because I've been a stay-at-home mom for 7 years because no resolution was met. I'm also asking I pay back 100% of the payments already made. Am I required to respond and agree? He's not paid any kind of support since October.
That's a long one. What are your initial thoughts?
Well, all right. Yeah, it is a long one. Let's break it down. I had an EDCM review this morning, no resolution. Do you know what she's talking about?
No.
Okay, so I think I do. I think this is a conciliation services mediation that is set when two people don't have attorneys with the court. I think that's what she's talking about. And so court ordered mediation at the court at conciliation services. They didn't reach a resolution. The ex wants, he doesn't want to pay utilities. So I'm assuming she's living in the house and she's not working. And he's saying, I'm not paying the utilities anymore. We touched on this. Does he have to continue paying the utilities while she is living in the house and not working?
So if they are married, there could be a spousal maintenance request that then she could use that money to cover utilities. But if they aren't married and this is a custody establishment case, probably not. You know, there is no housing stuff that comes up in just a custody case. It sounds like this might be a divorce. So with a divorce, there may be some claims for spousal maintenance, and then you could use that money for utilities. But it sounds like you may need to pursue a temporary order or something, because if he's just refusing to pay, you may not be able to change that up without getting the court involved. But you know, overall, you may need to start looking for some financial assistance in the meantime, because even getting the court involved is going to take some time. It's not like you're going to get the money right away unless he just agrees.
It also says he's asking that I pay back 100% of the payments already made. Am I required to respond and agree?
Well, of course, you're not required to agree. You're not required to respond. I would respond because a non-response can be used against you, but also it sounds like there's some negotiating that needs to be done here. So I would be responding and seeking to negotiate and raising the fact that, okay, well, what about the child support? If you have a claim for spousal maintenance, what about that? And hey, you know, if we can't resolve this, then I'm going to have to seek a temporary order. And then if the other side has an attorney, that's going to raise their legal fees. And so maybe they'll decide to reach an agreement with you rather than incurring those legal fees, because it could be a good $3 to $5 grand to get a temporary order. I mean, it can be very expensive in legal fees just for a temporary order.
Absolutely. What if the spouse left home, filed for divorce? Oh, I wanted to say one other thing. It also really matters whose name is on these debts. So if the utilities are in his name, he's kind of obligated to pay it because his name's on it. If it's your name, you're kind of obligated to pay it. So even though there's community obligations, sorry. All right, just one thought. Okay, next question. If a spouse left home and filed for divorce and overdrew the accounts, I'd pay his attorney with joint money and I haven't gotten it back. Even when the preliminary injunction was in place, he was continuing to pay. He didn't move out. He didn't move out and moved in with his paramour. And I ended up losing my house. Can something be done? My life has forever changed and I never got any money back.
I mean, you can use community resources to pay for a lawyer, and that's not a violation of the preliminary injunction. I need a lot more details on this. It's hard to really analyze the situation because I'm not clear on a bunch of the facts.
But if you've already lost your house, then it's gone. And there really isn't usually a lot you can do to get it back. Most of the time, by the time you get divorced, what the judge is dealing with is what exists today for me to divide. Even if one party blew it and the house didn't get paid, usually what happens is whatever exists at the time that you're dividing things is when you're getting half of whatever is left at that moment.
Maybe there's a potential waste claim. I don't know. We would need a lot more facts on that.
Right. Yes. Okay, next question. What's a quitclaim deed?
All right, so there's a warranty deed and then there's a quitclaim deed. So under a warranty deed, you're saying, I warrant that this title is good. I warrant that you're not going to have any problems with the title on this property. Whereas a quitclaim deed, you're just saying, I'm transferring my interest. I'm not making any promises about the title to this property. Now, I have had experience from time to time where a title company will not issue title insurance if there's a quitclaim deed in the title history.
Really?
So I almost always try to get a warranty deed instead of a quitclaim deed for that reason. And if you've been married and you bought the house via a warranty deed and nothing else has really happened with it, I don't see a problem with doing a warranty deed to transfer title to one spouse during the divorce. And I haven't had a lot of problems getting the other side to sign a warranty deed. So I'm a little cautious of quitclaim deeds for that reason, but it's probably a overly cautious approach. But those are the two types. And again, I would not do my own deed, either work with a title company or work with a lawyer, because there are so many nuances of things that need to be included in deeds to make it be completely accurate and correct.
Mm-hmm. Next question. I was bullied out of my house in June, and I got out some of my property if I granted him use and possession. Now we are selling, and he wants to list and be the buyer and rent it back. Do I have to?
Be the buyer? Why would he need to rent it if he's the buyer? That's confusing.
So sometimes when a seller sells property, they are not quite ready to move out and they rent it back from the original owner or from the new owner. They rent it back from the new owner for a period of time until they move out, because the ownership has changed, but the possession hasn't. So that part I kind of get, but I don't understand. Okay. But I don't understand really the rest of it. You don't live in the house. If the house is sold, he's living in it and he's renting it back from the new owners, you're still going to get your half of the money. And whether or not he's renting it from the new owners, honestly, shouldn't really impact you. And you probably should agree, if I'm reading this question correctly.
Mm-hmm. Yeah, I agree. We need some clarity on that one.
We do. All right. Next question. How do you use a judgment issued in the divorce decree to place a lien on property? Great question.
So the first step is to get a certified copy of the judgment from the court. It's generally a $30 fee plus, I think, 50 cents per page or something. So you'll need to pay for that. And then you take that to your county recorder where the property is located. Okay, so the county where the real estate is, and you record that judgment against the property. So it's helpful to have a recording cover sheet that explains, the property, APN and things like that. Also, Arizona requires, if this is a money judgment statement to go along with the recorded judgment to make it official. And so I don't have all the details of that memorized, but there's like 5 or 6 things that you need to put in the money judgment statement. The name of the debtor, their address, their, I think, date of birth or something, Social Security. I don't know, there's some information about the other side that you put in there. And that's required to actually make the lien valid.
Okay, so we should cover this in Win Without Law School, because that is gold. That is absolute gold. We should do a mini course on how to record your judgments. And we haven't even talked about Win Without Law School, but for those of you who are watching, if you don't know and you are representing yourself, or even if you're not, Win Without Law School is a company that Julie and I own together that is the very best resource you can get for learning about family law, how to navigate the system. Everything we talk about here is like so much more in-depth and thorough in Win Without Law School. How's it going, Julie?
It's been going so well. We're just putting in more and more content. Right now, just finishing up week 5 of the content and we're going to have around 10 weeks of content that takes you through each type of family law case from start to finish, shows you the forms, and then we also have Q&A to answer your questions. So really, you know, if you're representing yourself, you're really all alone, and this is a really affordable way to have somebody to help you through the process. So go to winwithoutlawschool.com, check it out, see what you think. We do have some specials on year-long memberships because your case can take a long time. And if you have children involved, there's other stuff that comes up down the road, even after your initial case. So this is a comprehensive program that'll cover all of that. Go ahead and say a few things, say whatever you want, and then I wanted to talk about the judgment thing one more time.
Okay, yeah. So I was just going to say, if you're at all interested, get on our list. It costs you nothing. Go to winwithoutlawschool.com and register, and we'll send you more information. Let's get back to these judgments. We should do a course, right?
We should, yeah. And when you record the judgment, you don't get money right away. Okay, so it's a lien on the property. And if the property that you're liening is your ex-spouse's, for example, if it's their what we call homestead, then you can't foreclose on the lien. You have to wait until they sell, and then you get paid out of the sale. And there's a certain amount of time that you have to renew the judgment. I think it's every 10 years. It changed recently. Well, not recently, but it changed in the last few years. But I think it's 10 years. But you have to do a judgment renewal to keep your judgment active. So there's a lot of complications with recording judgments. But it's certainly something worthwhile because sometimes recording it gets the matter resolved because some people don't want that judgment against their house. Or sometimes they end up selling and you get the money. Like, there's a lot of different things that can happen. In addition to recording the lien, recording the judgment against the house to create a lien, you can potentially garnish wages. If you have a judgment, you can potentially garnish bank accounts. That's a little bit more complicated. And you can even potentially seize property, but that is, again, is more complicated.
Good stuff. Let's see. How do I know if a disclaimer deed was signed?
It should be recorded. So it should be part of the recorded records for that piece of property.
Now, are your county records online and accessible to the public? I think they are everywhere in Arizona. So you can simply search the county where the property is located to see. Okay, my husband owned his house before we were married. We started a business together. He refused to put my name on either. I want to divorce, but I have to start over since I have no proof of income. And I have worked in the business for 6 years.
So this is a great question because this touches upon the community lien concept we talked about earlier. So if one spouse has a house prior to marriage, but then you get married and you both move into that house, and then you use marital money that you're earning during the marriage to pay the mortgage and upkeep the house and make improvements, you have what's called a community lien. Now, it's a somewhat complicated math calculation to determine that lien, and we're not going to get into all the ins and outs of it right now, but there is a way to do that. As far as this business goes, if it was started during the marriage, then it sounds like it's a community business. And so what's the value?
Right.
That's the tough thing with businesses is valuations.
It is. It absolutely is. And with a business, you didn't sign a disclaimer deed. So just because your name's not on it doesn't mean it's not community property, which is confusing because it's like with the house, if your name's not on it, it's separate property, but that's only because of the disclaimer deed. So if you haven't signed an operating agreement or something giving away your rights to the business, it is still community property. All right. I am 9 years and 5 months married and I've never worked. Can I ask for money for me?
In a divorce or just within your marriage?
Good question. Let's assume in a divorce.
Yeah, I mean, you can ask for spousal maintenance, which would be money for you. And in deciding spousal maintenance, one of the factors the court looks at is what are you getting in the divorce? So if you're getting sufficient money and assets in the divorce, then there may not be a need for spousal maintenance. On the flip side, if those assets and money aren't sufficient, the court could award spousal maintenance. But yeah, it is definitely a tough road if you don't have your own income going into the divorce, because either you need to get back into the job market, and that poses its own problems, or you need to get sufficient funds from your ex, and that can be difficult sometimes too.
I have sole legal and physical custody. Can I have a lawyer state who the guardian will be if I ever die?
So it wouldn't go into your court papers. I mean, you could maybe reach an agreement and put that term into it as part of your parenting plan. I guess that's possible. I haven't done that before. Usually that goes into an estate plan, and that's where I generally would draft it as part of an estate plan. But there's always a bit of a rub between what's in your estate plan and what the law says, because you could put in your estate plan that you want your sister to have full custody, for example, if you died, but she doesn't have, her rights to the children don't exceed your co-parents' rights. So you can name somebody, but that person you name may only have legal rights to do so if both parents are deceased.
Right. And if the biological and legal parent does not have any relationship or is dangerous, then you're probably getting into third-party rights, because a will cannot take away the rights of a parent who's alive, just like what Julie said. All right. Can we subpoena Venmo and PayPal? My 78-year-old father filed for divorce from a narcissistic, evil person who sent hundreds of thousands of dollars to her children while she controlled all the money, and he begs for $20.
How sad. Yeah, you should be able to get those records. Also, those transactions may show up through the bank records too, because a lot of those transactions go through a bank account. So if you're having trouble getting the actual records from PayPal or eBay, the bank records could be a good start. But yeah, I would imagine, I haven't subpoenaed those places, but you can do a request for production. The other side should have to produce that stuff. And then I would imagine you could subpoena those records as well.
Definitely. And if it sounds like what you're describing would meet the qualifications for waste. So I'm glad that you're helping your father.
There's waste, and then there's also a claim in Arizona called vulnerable adult abuse.
Ooh, let's talk about that for a minute.
It can be harder to prove, but it is, the language in that statute is dangerous, because it basically says that if you are in a position where somebody sees you as their caregiver and they're dependent on you that way, you cannot use their assets for your benefit. And so if you, and I had a horrible case about this when I worked out in Western Arizona, the marriage can be a total facade. This case that I had years ago was an aging gentleman. His wife had predeceased him. He was living on his own in the middle of nowhere in the desert, and he was starting to have some problems. And this younger lady with a history of drug problems, who's in her 40s, came in, took him to the courthouse, got married, got access to his bank accounts, and withdrew $300,000 and put it in a separate bank account in her name. So she's like, well, we're married. And it's like, no, this is, this is so clear cut that what you're doing is wrong. And so with this example that the person wrote in on, you can look to that as well. Like, was this whole marriage a total sham just to get into dad's finances? Because the penalties for vulnerable adult abuse, it's like treble damages. I mean, it is serious damages if you prove it. And even if you can't prove it, this could be a major point of leverage in resolving the case.
I learned something new and very valuable today. So you're saying even in a marriage, if one person is the caregiver, because of whatever reason, they've just become a caregiver, they can be held liable under this statute. And you can use that in your divorce in addition to a waste claim?
I think that the facts need to be very unique, like the case that I explained, where it's really clear cut that this marriage is just a sham.
Okay.
Because if you've been married for 20 years, you have joint finances, you know, that's a totally different situation.
Okay.
But if you're elderly and then somebody swoops in, and you know what the law is looking at is there's a total imbalance of power between a caregiver and somebody who's vulnerable. They're called a ward usually. And so when you are vulnerable, your whole world revolves around your caregiver. And you're like, oh my gosh, if my caregiver leaves, I'm not going to get food. I'm not going to get healthcare. I'm not going to get a shower, you know, whatever it is. And so you become so dependent and you're willing to agree to anything. And they're like, oh, well, I need some extra money. Okay, whatever you want, just don't leave me. Oh, I want an interest in your house. Okay, where do I sign? Like they will do the most unreasonable acts to keep their caregiver there. And so if you have a situation where somebody has come in and created a sham marriage just to get to the finances, yeah, I think you have a case for that. But if you have something where just you've been married 20 plus years, one side's aging, the other side becomes the caregiver, I think that's probably more in a waste claim arena if there's some wrongdoing with the money versus a vulnerable adult claim.
Love it. Okay, this is a fun question. So if I have my wife sign a quitclaim deed, does she have authorization to my home if we're divorced?
Does she have authorization?
I think he means a claim.
I mean, if she signs a quitclaim deed, that's saying I sign over all interest I may have in the property to you. So likely, yeah, that would stand. She may be able to say there was fraud or something wrong about it. She could have some defenses, but for the most part, if it's a valid quitclaim deed and she signed her rights over, then that should stand.
Yeah, it's an interesting question. All the case law is specific to disclaimer deeds, which disclaims a community interest specifically. So the quitclaim deed wouldn't have specifically disclaimed a community interest specifically, but it's the same thing. So, yeah. All right, next question. How do I get emergency temporary custody order pushed through faster? I cannot afford a lawyer.
Well, push through faster. I mean, if you're going on an emergency basis, that should happen very fast. You file your papers and the court starts looking at your motion. And it's so great you asked this question. We just covered this week in Win Without Law School. So if you're requesting what we call a motion without notice, motion for temporary orders without notice, you have a burden of proof. You have to show there's irreparable harm and why you shouldn't give notice to the other side. So if you have evidence of irreparable harm, you should be able to get relief pretty quickly. But when you get an emergency temporary order, it's called without notice or ex parte, it's only good for about 10 days. The exact amount of time depends on what the court orders, but it's generally about 10 days and it expires, and you still need to seek a regular temporary order. So if you don't qualify for the emergency relief, you can do a motion for temporary order and seek expedited relief. And you need to put your reasons why you're seeking expedited relief in there, and it'll be up to the judge. But wow, how do you move it along faster? Could potentially call the judge's assistant, check on it, see what's going on, talk to the clerk, see the status. I would have better information if I could see exactly what you filed, because there may be an issue with your filing and maybe that's causing a delay. I just don't know.
And Brianna and Julie, do you know if that course is up recorded now on Win Without Law School so that a member could access it if they joined?
Well, I know we did these Tuesday and Wednesday this week. So I sent everything to Brianna. I know she's uploading it. If it isn't there now, it will be soon. Go ahead, Brianna.
Yeah, they're up there.
Okay, great. So awesome. If anybody does need more information on filing emergency custody, you can get an entire course on that at winwithoutlawschool.com. If my husband is only a 25% owner in the home title and not on the loan, Is he entitled to 25% or 50%?
Well, if he has a 25% interest, then his interest would be 25%. Even if he's not on the loan, his ownership interest is still subject to the loan. So it's not like he just gets a windfall amount without taking the loan into consideration. His interest is still subject to the loan. And if, for example, the house was sold, he would have his 25% after the loan was paid.
Right. Absolutely. All right. There's a fun question over here. She owns a business and inherited it during the marriage. Can my dad file for half of the business?
So she inherited it. So that should be her separate business. I would want to know more about the business. Was this something where she was actively working in it all the time? Or was it a passive business, like rental real estate, or I don't know, something where there isn't a lot of active work going on with it? Of course, rental real estate can require management, but if it's some sort of passive business where she's not actively working in it, then it probably has remained separate, no claim. If it was a business where she inherited it, but then she's spending all of her time building that business, then there can be a claim by the community, because she could have been spending that time building up community assets, and the community can request reimbursement for all of that time and energy she spent building her separate assets. It's a complicated claim to make, but it is possible.
It's called a Rauschenberg claim. It's a complicated claim to make. If the business is not worth a significant amount of money, it is likely not worth it. Generally speaking, remember, this is not legal advice, just general information. So you want to talk to an attorney about that one, because it's a super complex legal issue. Okay, my other parent lives out of town. He's not able to see the kids during the week. Am I allowed to have weekends? Because he's asking for all the weekends and the holidays and the school breaks.
Yeah, in my experience, judges will carve out some time for the non-long distance parent, or the main custodial parent, to have some weekend time and some holiday time. So maybe it's like, okay, you get 3 out of the 4 weekends and I get the 4th. And if there's a 5th weekend, because some months have a 5th weekend, I get that too, or something like that, and then work out a holiday plan. But what I imagine is happening here is that the parent with less parenting time generally is trying to grab as much time as possible, because it makes a difference in the child support calculator. So if that's the real motivation here, where they're asking for all those times because they are trying to get a lower number in the child support calculator, you may want to consider a negotiation here. Look at the different numbers and be like, look, I want this additional time, but I'll keep your child support at this certain amount. Let's just be done with this. So you could maybe negotiate on the point if that's the motivation of the other side.
Absolutely. It would be unusual for anyone to have a parenting plan that never gave them any weekends or any holidays. That I've honestly never, in my almost 20 years, I've never seen that. So we are about out of time for today. Somebody asked again what that website was. It's winwithoutlawschool.com. There's courses up, and they can be purchased individually or in packages, and they're really good. Julie, thank you so much. It's good to see you. We'll be back here next Thursday, same time.